And the whole situation is my son was took out of my custody.
Hold on. I don't want you saying anything about the case. Court calls the case, People versus Justin Luttrell.
Alex Jablowski for the people.
And Assistant Public Defender Emily New on behalf of Justin Luttrell. Mr. Luttrell, can you please state your name?
Hi, I'm Justin Luttrell.
Okay, I have a plea form in front of me. Is that what we're doing?
That is correct, Your Honor. Mr. Luttrell wishes to enter a no contest plea to added count 2 of larceny $200 to $1,000.
A 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
That is correct, Your Honor.
Yes.
All right. Mr. Luttrell, can you raise your right hand, please, sir?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Justin Luttrell.
Okay, you can put your hand down. Sir, it is this court's understanding that you're going to plead no contest to the charge of larceny $200 to $1,000. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
Let me explain 2 things about a no contest plea to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to this charge. You understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, sir.
All right. Ms. New, basis for the no contest plea?
Potential civil liability.
All right. Mr. Luttrell, to the charge of larceny $200 to $1,000, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest to this charge?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed University of Michigan Department of Public Safety report for their case number 22-903-5358. Any objection to the court having reviewed that report?
No.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
October 13th at 8:30 a.m. with Judge Perry.
October 13, 2023, 8:30 a.m. before Judge Perry. Bond will continue. Thank you. Thank you, Mr. Luttrell.
Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Mercedes Mead.
Allie Zend on behalf of the people.
Overwater, Assistant Public Defender on behalf of Ms. Mead.
Ms. Mead, is that you on the phone?
Yes.
Okay.
Yes, it is.
This is date and time for a probable cause conference. The Defense has demanded a copy of a video that's indicated in the police report. It's allegedly a security video that has not been tendered. We have received the body cam video of the investigating officer, but not the security cam video that's referenced in the report. So I'd be asking to adjourn this matter so that the state can procure and produce that evidence.
Probable cause conference, October 5th, 2023, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls case, People versus Kevin Moat.
Good morning, Your Honor. Grace Broughton appearing on behalf of the people and standing in for the attorney of record, Laura Willenberg.
First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Moat, standing in for Mr. Feaster.
Oh, everybody just standing in. All right.
We're a helpful bunch, Judge.
Yeah, right. Okay.
Your
Is
Honor.
Mr. Moat here?
Yes, Mr. Moat, will you state your name, please?
Kevin Moat.
Thank you, sir. All right, what are we doing?
Your Honor, there's some discovery that needs to be shared still with Mr. Moat. We would ask for an adjournment to be able to meet with him.
And Your Honor, if I may ask for a date for a good reason, because the co-defendant in this matter is set for 9/28, and I would like the cases to run at the same time.
Okay. See, that was so nice how she did that. You know, Anderson could learn something from that.
I was taking
So-
notes, Judge. That was very nice.
Were you? Okay, good.
I'm blushing.
September 28, 2023, 9 a.m.
Hello, hey, Judge.
Thank you.
Hey,
Pardon?
Judge. Hello.
Hello?
Hey, I never talked to a lawyer or nothing. Like, I just be appearing in court and they be postponing it.
Well, they're adjourning it. And have you called down to the public defender's office? You have their number?
I have, Your Honor. I done called a couple of times, and the whole situation is my son was took out of my custody.
Hold on. I don't want you saying anything about the case.
No, this
Okay.
not pertaining to the case. He has nothing to do with the case.
Okay. What are you trying to tell me?
My son, the judge that gave me bond, and I was supposed to stay away from the defendant in the case or whatever the matter may be. But I have an 18-month-old son, and CPS is using these dates to keep my son away from me.
Okay, hold on. You're gonna have to talk with your attorney, but you've got to make sure you get in touch with them.
I've been calling them. I got witnesses.
Mr. Mo,
Yes, sir.
do me a favor. You have their number, right?
No, they never gave. I got your sister law firm number. And
Okay,
I called
well,
that. I
it's
called
probably
that,
it.
and I
Okay,
begged
Mr.
for
Mo.
discovery packs. I went to the police station where he told me to go to try to get my discovery pack. The police told me it wasn't down there. So I feel like I'm being railroaded by this person. Like I done did 11 years before. Like I'm not trying to be railroaded. If I can fire, can I fire this attorney? Yes, sir.
Mr. Moat,
Yes, sir.
if rather than talking, you'd listen to me, maybe some of the roadblocks that you're running into, we can get past them, okay?
I just missed my son. Yes, sir.
Okay, I hear you. Do you have the number for the public defender's office?
Yes, sir. I have it.
Okay, here's what I need you to do. I need you to call down there, make sure that they have your phone number and a valid email address.
They got that.
Okay, Mr. Mount, I'm done. Because you got something to say to everything I say. I'm done.
I apologize.
We'll see you on the 28th. Thank you. Mute him. He's out.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Bowden.